Welcome everyone and good evening. I'm delighted to welcome you to our Meet the Author event for the 8th edition of Defending Suspects at Police Stations. As we say, the Practitioner's Guide to Advice and Representation, which is published by the Legal Action Group. And this evening I'm joined by Sandra Paul and Matt Hardcastle from Kingsley, Napley, who I'm really delighted to say have taken up the role of co-authors. And I hope that the book, and that they will be with the book as co-authors and authors in the future for many years to come. And I'm also delighted to say that in the audience today as well is Jawaid Luqmani, who, on going back to previous editions, I realise has been with me on Defending Suspects at Police Stations since the 2nd edition in 1995, so a very long time, and I'm going to say a bit more about Jawaid later on. So I think I can see that maybe some people still with their microphones that haven't been muted, so probably that would be in the left-hand corner of your screen. If you could mute if you're not muted, and also stop the video for anyone other than a speaker, that would be of great help. As I'll say in a moment, one of the things that you will be able to do is to use the chat function to ask questions, and what we're going to try and do is pick up on questions later on in the session. So what we want to do this evening is to reflect on how far we have come since the 1st edition, and the 1st edition was published in 1993. To look at some of the landmarks along the way, the key provisions and developments that have been captured in this latest edition. And very importantly, what we want to do is to try and get some sense from you, the audience, how we can help you keep up to date in these very difficult times. So as I say, we're happy to take questions. If you could use the chat function to if you have a question or a comment to make, and I can't guarantee that we'll get through all of them, but we will try and pick on some of those later on in the session. So the first thing I want to do is to introduce Sandra and Matt. Now, Sandra is a partner in Kingsley Napley in the criminal litigation team, and she is the lead for the general crime group. And her colleague, Matt Hardcastle, who is a senior associate at Kingsley Napley. And what I would like to do is for them to say something about themselves before we continue. So first of all, Sandra.
Okay, so thank you for having us here and sharing this evening with us. So I think before I say anything about myself, I'd like to say a little bit about you, Ed, and some would argue that you need no introduction, and I think that's probably true, but just in case there are people here who aren't familiar with your awesomeness. Ed is a solicitor and emeritus professor of criminal law and practice at the University of the West of England in Bristol, and he's carried out research on the investigative stage of criminal proceedings in many jurisdictions, including countries in Europe and around the world, and wrote for the UN ODC a guide to access to legal aid, building on the UN's principles and guidelines on access to legal aid in criminal justice systems, which was adopted in 2012. And of course, his crowning glory, in my view, but I'll leave others to judge, is the reason why we're here tonight, because he is responsible for the definitive guide to advising at the police station, otherwise known as the Police Station Bible, in both firms in which I've worked, just called Ed Cape. You know exactly what you mean when somebody says that. We're going to talk some more about that later, but just to say for my part, I got my first copy of Defending Suspects in March 2001. It was given to me as I started in crime, and it has been something that's been with me ever since. I can't claim to know every detail of everything that is in that book, but I tell you what, when I go to the police station, if I have it with me, I know it's either in the book or the book will tell me where to find it. And some of the difficult and really unpleasant situations I've had at the police station make it just something that gives me confidence all the time. And I remember when Ed got in touch about the book, and I was completely fangirling. I was like, oh my God, I'm talking to Ed Cape. But actually what's happened since then is I'm still a bit fangirling, but what I take away from it is your generosity, really, and big brain, and your patience in dealing with me in particular. I'm really, really grateful to be involved in the project. I think, Matt.
Yes, I get the unenviable task of following the two of you. I mean, this book has been around. I hope it doesn't make Ed blush, but I think I was 8 when you first published this book. So it's not just my entire career, but the vast majority of my life has been spent with this as everyone's go-to book, which makes it quite an intimidating thing to join. I know that I started out being a duty solicitor, going to police stations all the time, and I think as Sandra was saying, you'd feel nervous and underprepared if you didn't have, if not the book, but access to it. And you know, I hope that that people still feel that way, because it just shows that the quality has stayed there all the way through. And hopefully that's what we'll be achieving in this edition and the ones to follow.
So, Ed,
yes,
could you tell us and maybe take us through how we got to where we are today in this latest and 8th edition, Finding Suspects?
yeah. So, well, one of the sort of questions well, which you put earlier was, why did I write the book in the first place, and where did the idea come from? Now, at that time when I started thinking about it, which was in the late 1980s, I was a partner in a Bristol firm of legal aid lawyers. We were doing increasing amounts of criminal defence work. And together with my partner, we had worked through the introduction of PACE, which came into force initially in January 1986. And it was evident from the outset that the police at that time were quite hostile to what they saw as being the restrictions placed upon them in doing their job. And initially there was a lot of police resistance to complying with it. There was a lot of evidence, both in my experience, but also the research evidence at the time, which showed that the police would often discourage suspects from asking for a lawyer. They were often aggressive in interview, and they took a wide range of steps to sideline lawyers. And in fact, one of the, I remember some of the first courses that we used to run, and we talked about the lawyer's pack that they should have ready to take to the police station. One of the things that someone suggested should be in there was a spanner, because initially what used to happen is that in many police stations is that the police would bolt a chair to the floor in the corner of an interview room in a very physical way of trying to sideline the lawyer. So there was a lot of police resistance, but also a lot of lawyers were unclear about what their role should be, because for most of them this was quite new. So they weren't clear what they should do. They weren't clear about how far they could go. And that was exacerbated by some firms that made extensive use of untrained and unqualified staff to attend police stations. And so, well, that really made me feel that for that whole range of reasons, that there was a need for the kind of book that eventually turned out as Defending Suspects at Police Stations.
Sorry, so 27 years ago, so did you anticipate that you'd be publishing an 8th edition? I mean, what did that mean?
There's a very short answer to that, which is no. I didn't even think about a 2nd edition. I think it has been an amazing experience, and sometimes I suppose I've felt a bit of a cheat, because by the time of the 2nd edition, or indeed by the time the 1st edition was published, the 2nd edition, I wasn't personally doing police station work. But what I've always tried to do is to keep very close to the experience of criminal defence lawyers doing police station work. And I've been very grateful for the large number of lawyers who've been in contact with me, asking questions, raising problems that they're having. So in that way, I've tried to keep in contact. And I think one of the things that's very striking now, thinking about the 8th edition, is how in so many ways, even leaving COVID pandemic aside, how we're in a very different position than we were when the first edition was published.
So tell us what it looked like then, as it were.
Well, initially, one of the most striking things compared to now is that there was the PACE had in effect introduced contemporaneous recording of police interviews, which amazing to think of it now, but prior to PACE, there was no contemporaneous recording, and what the police did was to write up an account at the end of an interview, and it often bore very little relationship to what had actually been said, not just said by the suspect, but also very little relationship to what the officers themselves had said in the form of their questions. And so initially contemporaneous recording was in the form of a written record, and that slowed interviews right down, so that even a simple shoplifting case you might have an interview lasting 2 hours, because the question would be asked, that would have to be written down. The officers would say, wait, don't speak yet. And so the interview became a very artificial process. As I said, the police resisted engagement by lawyers, and they have many ways of trying to do that, and many ways of trying to discourage suspects from asking for a lawyer, or from relying on the lawyer's advice if they did actually have a lawyer present. The police training on interviewing was extremely poor. And I think that was one of the reasons why the police were often aggressive in police interviews, because they simply didn't know how to interview effectively. And I think if you want to get a sense of what it was like, many of you will know of the Cardiff 3 case, the Paris, Abdullahi and Miller, the appeal of which was heard in 1992. And that involved 5 suspects, 5 defendants, eventually, 3 of whom were convicted of murder. And eventually, it was really, I suppose, one of the first cases where audio recording of an interview made a significant impact on the outcome. Not at the trial, because the judge at the trial largely refused to listen to the audio tapes, but the Court of Appeal did. And they made a very important point, which was that you couldn't understand from a written account the way in which that interview had been conducted. And they talked about the menace of the delivery of the police officers and the aggression of the police officers. And that had, almost all of those interviews had been carried out in the presence of a defense lawyer. And the Court of Appeal was very critical, because the lawyer had made almost no interventions during the course of 19 hours of police interviews, which, as I say, the Court of Appeal, in the case of the defendant Miller, found had been oppressive. So that was like a wake-up call. And just if you don't know of that case and want to know more about it, there's a fantastic podcast series on BBC Sounds called Shreds, which is about 13 episodes, but it is a really good account of the whole case, but also of the context in which the police were operating at the time.
I completely agree with you regarding Shreds. I cried at various points and was like insanely angry at others. So thinking about it now, apart from buy this book, what's the advice that you would give to others about attending the police station? I mean, it's, at times quite depressing. Why should we bother? What's the point anymore?
Yeah, I think it has become depressing. And one of the fantastic things, we've really, to use that well-worn expression, there's been a bit of a journey here. And when police station work initially became possible as a result of the changes in pace, there was fantastic enthusiasm by many lawyers and many representatives who went to police stations, and they really not only wanted to do their job well, but to an extent, because of the financing of it, were able to do the job to the best of their abilities. And running CPD courses at the time was a fantastic experience because of that enthusiasm. It was really something quite fantastic. And that has changed dramatically and very, well, what can one say, in a very unfortunate way, and I'm sure we'll talk more about that later. But I think the important thing for me is that we start from the point, and again, I think this will come up later, that the criminal trial starts at the police station. And in fact, for many people, it doesn't only start at the police station, it finishes at the police station for a variety of reasons. And it means that police stations are, I've got written here, the guardians of liberty. They are the guardians of liberty, but they are also the guardians of fair trial. You know, because if we think about who's there at the police station, the only person who is there to seek to ensure that their clients' rights are respected and to seek to ensure fair trial and to guard the liberty of subjects or citizens is the criminal defence lawyer. And in many countries in the world, the police keep outsiders away from police stations, as was the case here prior to PACE. And what that means is that there's no transparency and hence no accountability. And there is often, in many parts of the world, many of them, many countries close to home, there's often abuse and ill treatment of those people who've been arrested and forced confessions. And it seems to me it was true here, and it's true in many other countries now, that politicians and the judiciary often collude in that. They don't want to hear about the way in which people are dealt with at police stations. So getting lawyers into police stations has been one of the most important developments in criminal justice in my lifetime. Now, being part of that as a defence lawyer, whether you are a solicitor or a representative, is challenging. It's sometimes exciting, but I think it's always important.
You're on mute again.
Sorry, I keep doing that. I'm sorry. And so I'll leave it off now. If you were charting those 27 years then, and you're looking for landmarks, what would be the key issues that you would pick up?
It was, we talked about this earlier, and I sat down and tried to think, well, you know, what, because there have been many, many, many changes, but what are the most important? And so this is in no particular order. I've sort of thought of a number of things, and the first and most important, of course, was getting lawyers into police stations. That was a key thing and continues to be a key thing. The introduction of electronic recording of police interviews in the early 1990s was also very important. And I've explained the way in which, in the Cardiff 3 case, that was absolutely critical. And if it hadn't been for electronic recording, then probably those 3 people would not have succeeded in their appeals. And it's interesting to note that England and Wales still stands out in terms of electronic recording. There are a few other countries that do have electronic recording, but there is still a lot of resistance in many countries in the world. The police in this country did not want electronic recording. I think actually now they would not want to go back, but that's still the case in many countries. So even if you go to a country next to ours, France, or a jurisdiction next to ours, Scotland, electronic recording is still not routine. So that's absolutely critical, because unless you can hear and ideally hear and see what goes on, then written accounts, particularly when they're not contemporaneous written accounts, are useless really in terms of knowing what actually happened and what was said and how it came to be said. So that is one key thing for me. I think a second was that the Law Society fairly early on articulated in detail the role of the police station lawyer. And you know, many people many lawyers are sometimes less than satisfied with what the Law Society does, and I think that's often unfair. But particularly in relation to this point, the role played by the Law Society was very, very important, because again, in many countries, all that the bar does is to say whether a lawyer should act in their client's best interests, and that, for me, is not enough. I think lawyers need their role to be articulated, apart from anything else, to help legitimise what it is that defence lawyers do and should do at police stations. And what the Law Society also did in the, I think it was about 1993, was to persuade the Home Office to insert a positive description of the role of the lawyer in Code C, in Note for Guidance 6D, which is substantially the same now as it was then. And that is pretty much unique internationally, and I think very important. Moving on so quickly, conscious of the time here, but the effective abolition of the right to silence in 1994 led to the police changing the way in which they interviewed, and I think was an impetus for them to improve their interview techniques. But it also meant that lawyers had to change the way in which they approached advising clients before interview and also advising clients during the course of interviews. That was very important. The next thing is really been incremental, but you know, one might say that PACE is the last time that government paid attention to procedural rights for suspects and accused people. And what we've seen since is an accrual of police powers. It's amazing to think now that fingerprinting, when PACE was introduced, was not routine. You had to have approval from a senior officer. So that became routine. DNA samples weren't even covered initially by PACE, and they've become routine. Photographing wasn't covered at all by PACE, and that's become routine. Powers of arrest have been very significantly increased. I mean, they were increased in PACE itself, but then they were increased again subsequently to cover all offences. So, you know, and although, you know, politicians often talk about the balance being tipped too far in favour of suspects and defendants, but actually the reverse is actually the truth, because police powers have been increasing ever since PACE was introduced. And they haven't been matched by the rights of suspects, or indeed the rights of their lawyers. And just a couple of other things I want to mention. The introduction of accreditation was opposed by many lawyers at the time, but that was introduced back in 1994. And I think one thing one can say about accreditation was that it recognised the skilled nature of police station advice and representation, and was a very important step in trying to ensure minimum standards or adequate standards for defence lawyers. I'll mention the introduction of franchising and subsequently contracting, which I think sorry, I'm just having a problem with my screen. Let me just try and deal with that. No, I can't. So yes, the accreditation and franchising, and what I did want to say about this is that I would think that no defence lawyer, no legal aid lawyer is happy with the legal aid agency. And that was a colossal mistake, and it was unfortunately a bipartisan policy to shift from an arm's length organisation, the Legal Services Commission, to the Legal Aid Agency, which is wholly within the Ministry of Justice. And that has historically been a very bad move, and one, once we get a sympathetic government, I would want to see changed. And then finally, I think it's worth noting that for the first part of the, for the first decade or so after the introduction of PACE, the Home Office was interested in evidence-based policy. And they sponsored a lot of research into the way in which PACE worked in practice. And that interest lasted for about 10 or 15 years and has completely disappeared, so that the Home Office sponsors almost no research into the way in which PACE operates or police stations operate now. And I think that's a very big loss.
I share your enthusiasm for a sympathetic government. That's
yes.
Okay, so we've got to where we are today now. So let's continue the conversation.
Yes, so sorry for my hesitation, but my screen's gone completely strange, so I can't actually see what's happening. But let me just complete that by saying, well, what we are trying to cover in the current edition, the 8th edition. So what's new? Well, firstly, we have the various revisions to the PACE codes of practice, and in particular, a changed approach to defining mental vulnerability and in dealing with the gender of suspects appropriately. So that's the first key thing. Secondly, there are changes to the place of safety provisions as a result of amendments to the Mental Health Act 1983. Thirdly, although the changes to police bail without charge were introduced just before the last edition was published, there have, of course, been the developments and the massive use of release under investigation and the decline in the use of police bail without charge. So we cover that in some detail. And then finally, all of the relevant new case law. So we're going to hear about some of them, I think, from you, Sandra, later on, but we've got cases on arrest, on the right to silence, appropriate adults, legal professional privilege, out-of-court disposals. So those are some of the key new cases which we take account of in the 8th edition. Okay, so that's how we got to where we are today. And what I want now to do is to we're going to have a session where Sandra and Matt and also myself talk about some specific recent developments. And so the first, I'm going to ask Matt to talk about the COVID interview protocol.
Thanks, Ed. I appreciate from the start there will have been a broad range of experiences with this protocol, but we've had enough bad news this year. So I'm going to try and focus on positive parts of it. I think it's important that we remember where this came from and the chaos that was happening at the time this came into place. What we saw was the representative bodies, the LCCSA, the CLSA, the Law Society, speak to the MPCC and the CPS. And I can do no better than to quote from the protocol itself, that it was acknowledged that the coronavirus crisis involved the application of PACE Code C in circumstances which are unlikely to have been previously anticipated. It's wonderfully understated in terms of how that is put. But what we ended up with was a protocol that tried its very hardest to be fair, reasonable, and proportionate against all of the circumstances that we faced. And what we've seen since the introduction of the protocol, or certainly my experience since the introduction of the protocol, is that it has been applied in an organic way. There hasn't been rigid adherence to, we have to use a particular sort of software, or we have to connect by phone, we can't have anything else. officers have been really willing to engage in conversations to make sure that the solicitor's attendance was as close to a physical attendance as could be possible, and allowed you to be as effective as it is possible to be remotely. Now that can be using a mobile phone so that you have really clear signal, but then having a client call on Zoom on their phone, or having the police use a laptop so that you can see in, or vice versa. But the effect has been that you've been able to see and hear all the way through interviews, and completely clearly. And if you think back to the experience with police officers even 12 months previously, getting them to agree to do something that out the box would have been incredibly difficult. And so I think it's to everyone's credit that there has been that collaborative approach to trying to find a way through. The other thing that I just want to say about this is that every part of the criminal justice system has been really badly impacted by the coronavirus crisis. The backlogs at court are continuing, and they're growing each and every day. It is absolute chaos trying to get a listing, trying to get papers, trying to get anything to be effective. But the one thing that kept going all the way through was police station advice and assistance. And that's down to everybody who is here today, and that is down to everybody understanding that this was too important to simply be able to pause and finding a way through. And police station advisors don't always get the most appreciation in this system. We don't have the most glamorous aspect of this job, but we are the ones who kept going all the way through. And I think we should just take a moment to appreciate the effort that went into that to make sure that we ended up where we did. I think Ed's now going to talk very briefly about RUI if he's back on and running.
Yep, there we are. Yes, the new bail provisions has been introduced just before the 7th edition was published, and but we had little or no experience of how it's actually going to work in practice. Now, the government, the whole reason for those new bail provisions was that the government, Theresa May was then Home Secretary, it seems a lifetime away, that the government had intended to reduce the use of police bail without charge. So that was their aim. But I think the massive reduction in the use of bail by the police and the rise of RUI is something which the government certainly simply had not expected. And I think it's important to understand why this happened. Now, of course, with police bail, in order for a person where the police are not in a position to make a decision about charge, in order for the police to bail a person, then in most circumstances, that has to be necessary for a number of statutory reasons. And that term necessity or necessary is to be found in a number of powers that the police have, but it's been interpreted in very different ways. So we have necessity in relation to arrest. We have necessity for the purposes of detention at a police station under section 37(3) of PACE. And of course, we have it in respect of bail without charge. But as I said, the police have interpreted it very, very differently. So if we look at detention, the detention decision, when an arrested person is taken to a police station, detention has to be necessary to secure or preserve evidence or to obtain evidence by questioning. And at the time it went through Parliament back in the 1980s, Douglas Hurd was the Home Secretary, and he said necessary means necessary. It does not mean merely convenient. But the reality is that detention at a police station has always been more or less automatic. So necessity didn't mean anything in practice. And that was initially the case with arrest as well. And it was really only as the courts came to grips with defining what is meant by necessary for the purposes of arrest, that began to gradually change police behaviour. But in relation to bail without charge, it's as if the term necessity or necessary has been given such a high value by the police that they almost find it impossible, it would seem, to actually justify bailing a person rather than releasing them under investigation. Now, of course, in a way, that's not the case. It's not because they have interpreted or misinterpreted the word necessary in the legislation, it's really for other reasons they have wanted to use RUI rather than to bail people. And in particular, it seems to me that they've wanted to use RUI primarily to avoid time limits and also to avoid scrutiny, both by superior officers and by magistrates' courts. And it's really that, in my view, which explains why police bail provisions haven't worked as were intended, and indeed as the wording of the legislation would seem to suggest. Now, the Home Office has published recently a consultation. The consultation is now closed. But basically what that consultation was suggesting is tinkering with the legislative provisions, firstly by removing the presumption of bail, secondly by amending the timescales and the level of authorization for bail without charge, and then thirdly by creating some kind of non-statutory framework for RUI and voluntary attendance at police stations. Now, we wrote a submission, the three of us wrote a submission on that consultation where we argued that that simply wouldn't be effective because it doesn't tackle the reasons why the police are using RUI, or indeed the reasons why they made previously such extensive use of police bail, which is that it's become routine for investigations to take far too long, or either the investigations to take too long or for it to take too long for a charge decision to be taken. Now, of course, it is true that there are some complex cases which require lengthy investigation, and no one disputes that. But what we see is that the police and the CPS are taking ridiculous amounts of time to make decisions about relatively straightforward cases. And one would guess that very often no progress is made for weeks, months, and sometimes years, and not because of the complexity of the investigation, but because it's simply been put at the bottom of the pile. And the Home Office consultation, the proposals contained in that, would make no difference to that position. Okay, so that's what I wanted to say about police bail, and I think now Matt is going to talk about the Attorney General guidelines on disclosure.
That's right. So way back in 2018, the House of Commons Justice Committee conducted an inquiry into the disclosure of evidence in criminal cases. Following that inquiry and the recommendations made by the committee, the Attorney General launched a consultation, and the consultation response was published in September, and the guidelines are now available to see, and they will come into force at the end of this year to the start of next year. The part that's going to be most relevant for people attending the police station is Annex B, which is where they introduce pre-charge engagement. It's a voluntary process, and the code goes so far as to say that it should not be held against a suspect at a later stage in proceedings. I will eat my shoe if that's correct. And I think that it can be seen in the difference between the consultation response and the guidelines that have been published. The consultation response says that a failure to engage will not be used against a suspect. The guidelines say it should not be used against a suspect. So there's softening between the two documents already, and I think it's worth downloading a copy of the government response just so that you have it now in case I get proved right later down the line. Pre-charge engagement is set out over 8 points, and the core of all of these points is that it is a focus on the suspect. And it's to an extent difficult to see how that pre-charge engagement is really what it was designed to be, and how it is just trying to get more material from the suspect by any other name. For example, they will ask the suspect to consent to the police accessing their medical records. They will discuss ways to overcome barriers in obtaining potential evidence, such as revealing encryption keys. They will ask a suspect to set out keyword searches. So you can see that all of this is focused on getting material from the suspect. It's really not, it appears, focused on a suspect being able to say, here are some lines of inquiry that I think that you should be following. You can also see an immediate conflict between what pre-charge engagement is potentially meant to achieve and the way that, or at least the direction of travel that the courts have had in terms of responses in police stations. And as recently as R&CB from this year, where there needs to be a properly identifiable foundation for an inquiry before the police are going to go down a line of inquiry, in that case, a complainant's mobile phone. Here, you can see very clearly that as soon as there is a no comment interview, first question is going to be, well, where's the foundation for the inquiry if you're asking me to go get material from a suspect's phone? So I think that this, no matter what it says in terms of its aims and its intentions, is going to be something that becomes a battleground over the next few years. And I think it's going to probably take 12 months or so before there is a case which provides clarification about how this will properly affect suspects. But I'm afraid to go back to Ed's point about a sympathetic government, I'm not sure that this revision to the Attorney General's guidelines has been introduced by a sympathetic government, and I don't think that it will be interpreted sympathetically. The other part that I think this is relevant to is, I think, an increasing need for work at the pre-charge stage. So according to the CPS, for their data summary for the fourth quarter of 2019-2020, of those cases referred to the CPS for charging advice, 75% of suspects were charged. The conviction rate for the same period is 84%. So this is, in many respects, your best chance at stopping a case. And everything is pointing towards more engagement at an earlier stage. How that will be funded and whether it will ever be funded in a way that is appropriate or a way that protects suspects from having a two-tiered system is something that will need to be addressed at some point.
Thank you, Matt. So Sandra is going to bring us up to date with some case law developments and probably to say something, but very briefly, about the sentencing white paper.
Sure, I'm going to do that now. So I don't want you to be left thoroughly depressed by this event, but what you should take comfort from is there is some good case law in here, and what we've done is put together all the case law ranging from arrest, appropriate adults, right to silence, all in there with enough detail for you to know which bits are useful to you or to know where to look. But some of the key bits I'd like to draw to your attention, they meet the theme that's been started already with Ed and Matt in terms of what was a creep in terms of section 34 now turns into a gallop. So in there you will see the case of Arvid Green from 2019. And this is a really interesting case because it's about, it reminds us that it's the unreasonable failure to mention facts that are subsequently relied on in a defence that is important, not whether or not the suspect, now defendant, answered questions. And in this case, the case that had been put to the suspect at that stage was wholly inaccurate. And so you think, well, maybe he doesn't actually need to say anything because the facts that are being put to him are incorrect. In fact, the judgment goes further. It says, well, hold on a minute. It's not necessary to have specific questions put to you regarding an issue before an obligation to answer questions arises. That invitation to give an account is or can be sufficient. So in addition to all the other things that we do at the police station, we now have to divine what the question is that the officer might have put if the officer had actually said anything useful. In that case, he was shown some CCTV regarding an event, failed to respond to the CCTV, and that inference was permissible. That was hotly followed this year, and it's one of the cases that just got into the book. Actually, the proofs were in, everything was sorted, and the case of Black came up this summer, which took it one step further and said, well, actually, you know, the issue for this in this instance is that the suspect, as he was at the time, had actually lived through the events that he was being questioned about. And that was sufficient to give rise to an obligation to answer the questions, or certainly the failure to do so or mention facts which you rely on then was sufficient to amount to or justify an inference at a later stage. And this case is interesting in that he received at the police station something like 2 pages of disclosure, but yet the case summary that was provided, I think in not long after he was interviewed, was something like 71 pages long. And so the disparity between the quality of the information was clear to anybody, but the court said he had been given some disclosure, that he was an intelligent and articulate person, which is, I don't know how you're going to describe that or measure that in the future. The suspect was given and understood the caution, and as I say, that he'd lived through the relevant events, and also that he had a version of events which was capable of showing that he was not guilty. And those things combined were enough to create an obligation on him to mention those facts, and his failure to do so was held against him. And it's one of the things that Matt noted really interestingly in our discussions about this case, was that there was no evidence adduced at trial in respect to this one about the advice that had been given at the police station. And whilst we kind of all agree that there's no obligation on him to do so, what I took away from it was my notes need to be on point, you know, in terms of the advice that I've given to the client regarding the legal analysis that I've made about what is important or not to mention at this stage. They just need to be written really carefully, really clearly in my notes, so at least the client continues to have the option of relying on that if necessary. Matt's already mentioned CB. If you haven't read it, you've got to read it. It's a brilliant case. And it is going to be, I think, at the foundation of some of those lines of inquiry that we are raising in the police station in the future. I think there's no way around the lines of inquiry, and I agree with Matt that they're going to end up as inferences at some point. Another question where I felt like case where I thought that the court was speaking to me personally was the case of Iqbal. And I don't know if you've read this case, but essentially this chap is released under investigation for a period of 2 years. He's arrested as he's entering, as he's coming in from Calais. He's interviewed by the police the following day. He goes back a year later for an interview, requisitioned, taken to attends court voluntarily. And when he gets to court, he's remanded in custody. And so it goes through an appeal process, and then the decision regarding the refusal of bail is JR'd. And the court says a lot of things, including, there is, we have to go through the normal process in looking at bail. Just because a police officer has granted it before doesn't mean that the court must now. But the court said this, and this is the bit I thought was speaking to me. The court was told that defence solicitors currently advise their clients that if they are released under investigation and then receive a postal requisition, they will not be remanded in custody if they comply, and have in the past complied with all the attendance requirements. The court said, if this is indeed a practice, there is no proper or principled basis for it. The full history and background will be taken into account by a court, as was the case here, but there can never be any guarantee to bail once a defendant is charged. So that was just a timely reminder. There are more cases in there. I was going to talk about Clark and Hobbs and the really important applicability of those cases to the decision to charge and public interest, the representations that we are all making at the police station, but we are so out of time. Just a nod to, there is going to be a whole bunch of stuff that is happening between now and the next edition. There is a lot of activity in this area at the moment, and most of it is troublesome. And so you can see the recent white paper on sentencing reform, which is going to limit the options in terms of out-of-court disposals. These are all things that we're going to need to keep up to date with so far as we can over the coming period. So there's a lot to happen before the next edition, and Ed's going to remind everybody what we're going to do to help.
Thanks very much, Sandra. So a lot to cover, and probably we could have made this 2 hours quite easily, but I imagine that many of you want to get to your dinner. So, but we will go on to, because we started a little bit late, we'll go on to about 6:05, but no longer than that. But of course, feel free to leave if you need to or wish to. So, as Sandra said, what we of course have done with the 8th edition is to have everything up to date until more or less the date of publication. But of course, things move on very quickly, and so one of our aims is to see how we can help you in terms of keeping on top of latest developments, both in terms of case law, law itself, and policy. And even just in the past couple of weeks, for example, there's been a case called Rasheed versus the Chief Constable of West Yorkshire, which is a case about, or one aspect of it is about arrest and necessity for arrest. And the court found in that particular case on the facts that the arrest had not been necessary. So there are those kind of changes. So what can we do? Well, as I'm sure you know, we do a biannual police station update in the magazine Legal Action in April and October, and we will continue to do that. And of course, the October edition is out just about now. What we're also planning from as an innovation with this new edition is to have a dedicated web page at the LAG website for defending suspects at police stations. And what we plan to do there is to post information about recent cases, about legal developments, consultations, etc. So that that'll be a quick way of trying to see whether there's anything new that you should know about. So that will be hosted on the LAG website, and we'll be providing more information on that in due course. So we have, and I'm sorry, it's shorter than it should have been, as usual. Particularly, I always have the tendency to go on longer than I should, but we have a little bit of time for some questions that have arisen. And we've had a couple of questions in advance. So if I can direct this one to Matt, there's a question from Kim Evans at the Justice Gap, and I'll just read it out. She says, sorry, he or she, I'm not sure about Kim, I don't know. Due to an ever-dwindling lack of investigators, clients are now spending increasingly long periods of time in custody before an investigator or officer is ever assigned to their case. 12 hours is not unusual. Custody officers seem disinclined to exercise their responsibility to ensure a detainee is being dealt with expeditiously. Why would they when it must be a fruitless exercise? So what is your view on this, please? So Matt, would you like to say something about that?
Yeah, so my view is that it is a real issue, and it has been for some time. As of 2009, the average length of detention was 9 hours and 18 minutes. And I've taken that from the work of Dr. Vicky Kemp, whose articles in Criminal Law Review from 2012-2020, I would strongly recommend. I think, and I hope this isn't our answer to everything, but your best bet is to rely on PACE and Code C. Code C requires all persons in custody to be dealt with expeditiously and released as soon as the need for detention no longer applies. You then have the trigger points of the reviews at 6 hours and then at 9 hours. If you don't think that your case is being dealt with expeditiously, make sure the calls are there, make sure it's added to the custody record, make sure it's present for each and every review, so that if it comes to the point where a review for the overall detention time is being considered, it is going to be far, far harder for an inspector to satisfy themselves that the investigation is being conducted diligently and expeditiously. And I think that is probably the safest route through for now.
Thanks, Matt. Now, Sandra, I've got a question for you. It's from Jill Ambler, who is a police station representative, and what she asks for is your thoughts or guidance on dealing with advising on intimate samples when you're remotely attending. Are there any particular issues that one should take into account?
I think that it depends on when the issue comes up. I mean, it's very rare that I'm at the police station when you're needing to give that advice. Often that part of it has come and gone by the time I get on the phone. But I think that you've got to do what you would do in person in terms of giving that advice, and identifying where the police are permitted to take those samples, and ensuring that your client doesn't end up in difficulty in terms of their resisting the police under those circumstances. I think that I think, and there are a couple of questions I can see there regarding remote advice. There is no doubt in my mind that it is more challenging in many ways in terms of getting people safely through the police station and properly represented. What we've got to be mindful of all the time is, if I don't feel that I can do what needs doing remotely, then I need to find somebody to go to the police station if it's at all possible. And having your mind always that, you know, you can switch if you need to, and being quite robust about that. I don't know if that's good advice or not, but those are my views.
I think it's also, I think it's also more challenging to identify vulnerability remotely, unless you've had the opportunity to see a client beforehand. I think everyone will have experienced going to a police station and the police officers just saying, oh, everything's fine, it's fine, and you going and you sitting down, you meeting with your client, and it's apparent from their cadence, from their behavior, whatever else it is that triggers the point in your mind that you think, actually, I'm not sure that this person here isn't vulnerable and wouldn't benefit from the assistance of an appropriate adult. And I think that is the real weakness of remote attendance, is if you are doing it without the ability to see a client either in person or for a significant period of time before the interview itself.
Thanks, Matt. One final question. I've got a question for either of you, if either of you want to pick this up. It's from Kate Hawkins. And she asked, how do you think the remote attendances are impacting on the training of probationary police station representatives? Any thoughts about that?
Badly. I think the only way to put it. I don't think it's the same thing. I don't think you can get the same training. I wouldn't feel, if I was starting out afresh, I wouldn't feel comfortable doing remote attendances and then being sent out to the police station in person. And I think that it is something that will need greater care. And the problem is that puts probably more pressure on overstretched firms already, because they will then have to try and find a way to keep people potentially going through that training process slightly longer than they would otherwise have needed to.
Well, thank you, Matt, for that. And it's a very important question, and one that I haven't seen raised before. And so thank you for raising it. And it's certainly something that that needs not just thought, but some action on, because otherwise we are going to have a group of probationary representatives who, if this continues for some time, are not going to have had the experience or much opportunity for personal attendance at police stations. So thank you very much to Sandra and to Matt for their contributions this evening. So I just want to say a few things by way of wrapping up. I'd like to thank everyone for attending this virtual launch and Meet the Authors session of Defending Suspects at Police Stations, the 8th edition. I know that both Sandra and Matt would join me in thanking from the bottom of our hearts the publisher, Esther Pilger, and her team for her continued belief in defending suspects in police stations, her willingness to take on board new ideas, her unceasing commitment, and the amazing amount of work that she and other LAG staff have done, both in relation to this book and this event tonight, and to their work generally. I mentioned at the beginning Jawaid Luqmani, and so I want to pay a special thanks to Jawaid. As I say, he joined me in writing the chapter on immigration, back in from the second edition onwards, and he's contributed to the book ever since then. And that was initially 25 years ago. I can hardly believe that. And immigration law, it has to be said, is to many criminal lawyers, I think to many lawyers, is a closed book. And Jawaid has done a fantastic job in making that accessible for criminal defence lawyers in his chapter in the book. And I think that your contribution, Jawaid, has been absolutely invaluable. And I really want to thank you for the work that you have done, and hopefully the work that you'll continue to do. So this book...
Sorry, I should say, I'm not sure you should be speaking to me being a lefty lawyer or an activist lawyer or whatever the epithet is at the moment. So I don't know if that's a good idea.
Yes. I think we should all add to our Twitter handles some, lefty lawyer or activist lawyer or whatever current insult the government wishes to address towards us. And it's a pretty sad state of affairs. This book has been published over nearly 30 years, and to a large extent the criminal justice system is supported by the dedication and commitment of criminal defence lawyers, something which is completely underappreciated by this government and indeed by successive governments. But what we hope is that the book will continue to support you in your work and in a small way contribute to sustaining fairness and justice through turbulent times. Thank you very much and good night.